Lordship, I have personal problem.
What personal difficulty?
Lordship, actually, I'm shifting my residential house, so I'm busy on the
Okay, right. Mr.
M. Mohantam for respondent.
Mr. M. Manta, learned counsel for the respondent, prays for adjournment on the ground that he has got some personal difficulty. As the same is not objected to by the learned counsel for the appellant, this is the matter
After
after
vacation.
the vacation.
High level.
May I please, Your Honor? I recommend item number 7, madam.
Okay. 7 and 8
7, madam.
together.
We are for item number 7, madam.
Your name is?
D. Bora, madam.
You're for whom?
I am for Biswajit Hazarika, madam. Item number 7.
There is no Hazarika
That's it.
in item 7.
But no, there is petitioner name, madam. Or appellant name, madam.
Who is the counsel?
Council PK Das, madam. He is not present today, madam.
Where is he?
He is out of station, madam. For today.
What about the appellant for number 8? Who is the counsel in number 8? Have you taken the consent of the council?
Yes, madam. Yes,
Because it is an analogous matter.
yes, madam.
Then if 7 cannot be done, 8 cannot be done.
Yes.
Then-
Madam. We have submitted the examination petition earlier, madam.
Right, on the prayer for adjournment made by Mr.
D. Bora, madam.
Who is this K Das, additional PP?
I'll call it.
Yeah, I've got. He never appears here. He's given no objection.
I think it's, I don't know.
Okay, right.
Maybe not.
On- On the prayer for adjournment made by, on behalf of Mr. P.K. Das, Learned Counsel for the appellant in criminal appeal 146/2018, which has not been objected by Mr. K. Das, additional PPSF. This is the matter. After the case.
After vacation. Published.
Yeah, 2018 matter. What is this?
19.
POCSO matter?
19, madam. 302, madam.
This is the matter after the case.
Published.
Please, Lordship. Lordship, I beg to mention item number 4.
4.
Lordship, due to difficulty of the conducting counsel matter will be examined.
Huh?
Due to personal difficulty of the.
No. What do you mean personal difficulty? No adjournment. You wait.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 9, Lordship.
Who's having a problem?
Lordship, Mr. A.M. Bora, Lordship, we had to leave the
Okay, right.
station.
On the prayer for adjournment made on behalf of Mr. A.M. Bora, Learned Counsel for the appellant who is out of station. And as the same has not been objected to by Ms. S. Jahan. Is it S. Jahan?
Yes, Jahan, Lordship.
S. Jahan,
Lordship.
additional PP. This is the matter. After vacation.
Highly obliged.
Public.
My please, Lordship.
Yes.
And for the appellant, Lordship. And it was for mediation, Lordship, and our mediation became successful.
Successful. So we
Sure.
we must the appeal.
See, para 16, payment page, para 16.
Para 16.
Para 16.
Okay, para 16. Yes, section 51.
Yes, my lord.
Yeah.
Of India provide that the provision of Code of Criminal Procedure was 1973 to of 1974 shall apply insofar as they are not inconsistent with the provision of the Act to all warrant issued and arrest, search and seizure made under the Act. Subsection 4 of section 100 provides that before making a search under this chapter, the officer or other person about it to make it call upon two independent and respective inhabitants of the locality in which the place is to search or situated or any of the locality. If no such inhabitant or such locality available or willing to be a witness of the search, to attend and witness the search and may issue an order in writing or any of them to do so. Section Subsection 5 of section 100 provides that search shall be made in their presence. Therefore, as per requirement section 4 and 5 of section 100, read with section 51 NDPS Act, the officer makes search is under obligation to make an endeavor to call upon independent respectful person of the locality where the search is conducted or from any other locality, and search shall be conducted in their presence. Here in this case, my lord, what happened? They have failed. Accordingly, the appeal is allowed and the conviction of the sentence is set aside. So this independent witness must be there, my lord. And there is one another Supreme Court case also, my lord, regarding this, my lord. We will also go through the Supreme Court cases. 2003-9 Supreme Court SCC 159. Para 6.
Yes,
This is Lordship, my lord. According to PW1 Dudnath Ram, the two punch witnesses were with him and both of them belong to village Hanspalia. These witnesses were present at the time of alleged search and seizure. During cross-examination, however, PW stated that both the punch witnesses are summoned after accused were made to get down from the bus with the attaché. That means this case is similar to us. They were called after the search was made, and they called the witnesses. And they witnessed both search and seizure of the opinion PW2 Shankarlal deposed that no search or seizure took place in his presence. This is our similar to our case. After being summoned, took place in his presence, and that he was asked to mark his thumb impression on a paper after being summoned from the field. According to Chogalal PW3, his signature was obtained on the Panchnama in the house of one Majid Khan, and no recovery of opium took place in his presence from the appellant. In the face of all the evidence, we do not find it safe to conclude that the prosecution has established the case against the appellant beyond a reasonable doubt. The appellant, in our opinion, is entitled to the benefit of doubt. We accordingly accept the appeal and set aside the conviction. So this case is similar to us. After the seizure,
your basic case is no independent witness
yes, my lord.
for the search and seizure,
Yes,
for the search.
for the search.
That's all.
After the search, then they call the independent witness.
Anything else?
No, my lord, I'm coming on. Madam, in Nooragha was the state of Punjab, no? Punjab. There is one guidelines, is there the standing order given by and speak for your lordship will know this.
No, I don't know. Then-
There are some standard guidelines has to be followed. I mean, judging today, sir. While content is such, some guidelines has to be followed.
Guidelines made by whom?
Just This is given by Minister of Home Affairs, Government of India. Yes, Government of India, Minister of Finance. Minister of Finance. This is the dated standing order dated 189, dated 3689.
Is there a newer version of this guidelines?
One guide, yes, 2-3 guidelines is there. There is also drug law enforcement field officers handbook. I can give you. And this is published by Narcotic Control Bureau.
Now, what is wrong?
Here, my lord. And when if your lordship go through that standing order, para 2.2, just read my lordship, para 2.2. Section 2, general procedure for sampling, storage, etc.
Yes, 2.2.
Section 2.2. All the package container shall be serially numbered and kept in lots for sampling. Sampling from the narcotic drug and psychotic substance shall be drawn on the spot of recovery. In duplicate in the presence of such witness, and the person for whom the poison drug is recovered. And the mention to the effect should invariably be made in the Panchanama drawn on the spot. The quantity to be drawn in each sample for chemical shall not be less than 5 grams in respect of all narcotic substance. In case of opium, ganja, and charas, where the quantity 24 grams in each case is required for chemical test. The same quantity shall be taken for duplicate sample also. So in my case, my lord. Then my lord, in my case, what happened, I'm coming, my lord. In my case, what happened? No sample was taken. And no seizure was at the time of search,
52A not complied with.
not compliant. No, no, I'm telling you, sample 52A compliant. Sample query. So sample was taken not on the spot, man. Not
So
on-
what is wrong? Sample, if sample is taken before the magistrate, what is wrong? That is the best way.
no message was there also.
No, you, after, it is not, you see,
No.
magistrate is not supposed to be there at the spot. After the seizure is made, they go to the station. From there, they make their list. And then they go with that list to the concerned magistrate. The magistrate compares that. And then the sample can be drawn there also. What is wrong?
I'm telling my lord, why I'm telling sample, yeah, okay. Take for instance, that the sample is from magistrate, okay. Now, my lord, what happened during the search, my lord?
Where is the violation at?
Yes, I'm telling violation is there. What they have to do? While after search, after seize the article, they have to keep in a certain go down.
Are you sure?
Yes, para 3.2. All drug must be stored in safe and value.
That is after it is, after 52A. It's complied with.
Yes, my lord, what happened?
What does 52A say?
A says that 52 A says disposal is narcotic drug and psychotropic substance. The central government may, having regard to hazardous nature, evaluate to tape substitute constant or proper storage space or any other relevant constraint respect to any narcotic drug, psychotic substance by notification the official specified sign narcotic. This is regarding disposal of these articles.
Okay, 52, come to 52.
Yes, well. Disposal of article arrested says any officer arrested person under section 41, 42, section 42 of section shall soon be informed to him on the grounds of such a day. Every person arrested as attached as the warrant shall be forwarded without unnecessary delay to the magistrate by whom the warrant is issued. Every person arrested in article 6 under section 2 of section 40 or 42 and 44 shall be forwarded without unnecessary delay to office in charge of nearest police station. The power person officer important section 53. The authority or officer to whom any person article is forwarded section 2 shall be all on convenient dispatch take such measures as may be necessary. So he should be forwarded to the magistrate. So my lord, if I go through the my lord, I'm just giving you one drug law enforcement field officer handbook. This is here guidelines, my lord. The guidelines were given, my lord. Field officer's guideline, my lord. If you also go to the field officer's guideline, this is prior to 52A.
No, you come to 52A2, you are reading one only.
52A2.
Yes.
Where any narcotic psychotic substance has been seized and forwarded to officer in charge of police station, the officer important section 50, the officer referred to the section shall prepare an inventory of such narcotic substance, contain such data related to description, quality mode, and etc. Or the packing with their pack, country or origin and other particular officer may consider relevant to the identity of narcotic substance, control substance or conveyance any proceeding under the act, make an application to any method for the purpose certifying the currency or inventory so prepared, taking in the presence of such magistrate photograph of such drugs or certify such photographs to the allowing to draw representative sample. When the application is made on subsequent to the magistrate shall as soon as may for the allowed application. Yes. Not missing any content inside every both trying an officer shall treat the inventory of photograph. That means after seizure they will.
Yes, they've got to follow this.
Yes. Between my lord, what is the between the search and seizure? There is a gap in my case. time gap. Time gap is there. If you also go through
You
a,
see, those issues we will see at the time of hearing the appeal, not at this stage.
no, my lord, this is the report, my lord, I'm telling you, where is the difference, where is the deficiency?
We cannot go minutely into the details of the evidence, into the merits of the evidence. at this stage.
So basically you want to say that there is a total non-compliance of section 50, 52,
52.
52A
Yes, my lord, what I'm
or
telling
what?
you, yes, my lord, what I'm telling you, that seizure was made at 1:30 PM as per FIR.
Now
And
see,
that
from here it is a,
seizure made at 5 o'clock. As per seizure list, 4 o'clock. So
Hmm.
there is a gap of 3 hours. What happened during the 3 hours? At that time, individuals were called out.
A search was made at what
One-
time?
So 1:30 PM,
And the Caesar report made at Caesar.
4
came
o'clock, 4 o'clock. As per seizure list.
obviously it will take time because they have to inform the higher authority, they will come, one person is coming.
No.
Thereafter,
that
the-
is
all
what-
the
that
process
time
will be
only different individuals there. So how many quantity, what is the quantity? If you suppose,
It is not a case that independent witnesses were not there, independent witnesses were there. One
Yeah,
and
yeah,
two are
I
the
understand. At the time,
independent witnesses.
only
So you
4
cannot
o'clock.
say there's a total non-compliance, there's a witnesses were there.
Anything else?
My lord, and the another point is very important point, my lord. The
Last point.
So many point and another point also there.
No, you bring out the important point.
Oh,
See,
important point, that's
all the
section
nitty
41
gritty will not be taken.
No, my lord, section 41 too, very important. Section
What you are
41.
there.
41 too. Very important. What is this? Section 41 too says.
So the empowered officers.
Yes, he is not an empowered officer. They have failed to establish.
Who are the persons who had made the Caesar and arrest?
My lord, if you lost it, come to page 102, my lord. FIR. I informed Sanjay Kumar Laskar, Fakirgram Camp Division, a written authorization were issued to me by IRF Fakirgram.
Page
is it?
102.
102. FIR.
Yeah.
I informed Sanjay Kumar Laskar, IRF Camp Fakirgram Camp Bongagao. Accordingly, a written authorization was issued to me by IRF Fakirgram by November so and so, who is empowered by government of Assam by notice so and so under section 41 to independent to carry a search and raid. When the train they were arrived in New Bangladesh, the police and headed by me with police person. Huh? Yeah, with namely yes, sir. So, my lord, there are two parts, my lord. In 41 to there are two parts. Firstly, he must be a gazette officer and he should be empowered. Second is, my lord, the person who is empowered, he can also authorize other person also to conduct that. Here, in my case, if you also go through evidence, you will find, my lord, second part is compliant with. Yes, I have empowered, I have authorized it. But my integrity, my identity has not been proved, whether I am authorized or not. That has not been proved.
No, but where have you challenged that?
Yes, I have challenged.
Now see here, OC authorized the person. There's
Authorized.
an authorization was there, but as per you, OC is not the authorized person. He is not.
OC is not a gazette officer. He may be a sub inspector also.
You have to see them. OC,
OC Sanjay Kumar Laskar, he is the ASP. I informed Sanjay Kumar Laskar. His credentials were not proved. Sanjay Kumar Laskar, whether he is a gazette officer or not, that is not been proved.
No, you see, police is a different issue. 41 will be deals basically with the other departments of the Central Excise, Narcotic, Custom, Revenue Intelligence.
No,
It doesn't talk about police.
My lord, My lord, this is Manipur High Court judgment, my lord, you could Hariman, Hari Mohan Singh versus State of Manipur. Here, my lord says, my lord,
Yes,
7 page, last para, my lord, 7 page, last para, 7 page,
7th page.
7 page.
Which paragraph?
Paragraph. After 12, my lord, after 12,
After 12.
after 12.
Paragraph. Rakesh, NDPS. This is after 12.
After 12.
After 12 is this, which part?
Yeah, after 12, my next page, my lord, if you turn next page, last paragraph,
Yes,
page after 12.
perusal of the.
Yeah, perusal of the affordable deposition PW1. I will show that though he has mentioned
Just a
about
minute, just a minute. Perusal of- perusal of. Okay. There's no big number. Perusal of- Yes,
perusal of the aforesaid deposition of PW1 would show that though he had mentioned about submitting the requisite information in writing to the SP BAPS, who issued the authorization letter to him to enable him to carry a search. He has not mentioned whether the SP BAPS was the authorized officer in terms of section 41(2) as authorized by general or specific order of state government. No such order specifically generally empowering the said SBPS to issue such authorization letter as provided in section 41(2) has been mentioned or produced by the prosecutor. Therefore, the contention of the petition that in absence of R. Boral, a production indication issued by the government show authorization of R. Boral, the prosecutor failed to prove that R. Boral is indeed the authorization officer in terms of section 41(2) stands substantiated. One was under the prosecution to prove this vital and material fact, which in the opinion of this court, the prosecutor failed to discharge. So on this onus on the prosecutor to prove that he is the author of it, he has failed to discharge in my case.
did you take this plea before the, did you raise this point in your cross before in
The trial court.
Trial court.
Yes, I've taken.
Where? Only the second,
Only second part had been adjudicated. That second part,
second part meaning the delegation of the.
yes,
authority.
delegation.
But the empowerment of
First
the,
part is not adjudicated.
so what do you mean to say that the
Adju-
person, the
Person who has info, he is not authorized. Is not proved. So if I go to that, then I have to read the whole evidence, my lord. Section page
I am quite sure the OC has been authorized.
85, my lord, should go to page
I'm
85.
quite sure the OC has been empowered. All inspectors are usually empowered. Even sub-inspectors are empowered.
But he must be gazette officer. OC is not a gazette officer.
No, where does it say, gazette officer? You look, these are two parts. Two says by general or special order by the central government or any such officer of the revenue, drugs, control, or any department of a state government as is empowered in this behalf by general or
yes.
special order. So, or any such office of the revenue, drugs, control, excise, police, or any other department.
Yes,
It
ma'am.
does not say gazetted with regard to the state police.
My lord, he has judgment.
No, I am quite sure there has been a delegation. Anyway,
my-
that is a different issue. We'll take it up at that issue will be taken up at the time of the appeal.
Well, this judgment of the same judge, Manipur High Court, it says that the perusal section 41(2) would reveal that any officer of gazetted rank or police officer or any other department mentioned they are in the state body empowered as the empowering by general special or the state government. It is reason to believe.
This is with regard to the state of Manipur,
Yes,
and this is by the Manipur High Court.
so my lord, substance, my lord, I'm telling you, just so since there are so many loopholes and Yeah, the procedure has not been followed, actual lordship, we find out. So, and the chance of succeeding, winning the case is quite bright, my lord, if I say wrong. So he should be released on bail, my lord. Oh no, one important thing, my lord, I have forgotten to tell. That I have annexed, he is a physically disabled person. The medical certificate, my lord.
Physically disabled person.
Yes,
So what was he doing?
yes, my lord.
What was he doing in Guwahati?
He is just traveling, my lord, he's coming,
Traveling,
my lord.
traveling, disabled person, very fit to travel
My lord, my lord, he had a.
without any luggage. Did he have any luggage while traveling or he's going to buy clothes along the way? In that blue bag which he was holding is not his.
My lord, just
Trolley
physical
bag.
disabled certificate. My lord, I'm just read out, my lord.
So do you travel without any luggage or do you travel with luggage?
Yes, my lord, there's a, I have annexed that copy, my lord.
Huh?
There's an access civil surgeon come, medical officer Dhanbad. I just read out, my lord.
Ah,
He
no,
cannot travel without the assistance of the escort.
he cannot travel without
Without
the assistance of
the escort.
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 So those two persons who arrested with you, they were your escort. No. And all three of you all didn't have any luggage,
My lord.
is it?
So he is a developed
So
disabled
three of you
person.
all were traveling, you all were going gallivanting in Guwahati railway station without any luggage.
Yes, my lord, and he is suffering from, my lord. I have annexed the medical certificate, my lord, given from Bongaigaon GRPS, annexed EU, page 161. So considering all this thing, my lord, it should be released for the time being, my lord.
Anyway, let us hear the other side.
Lordship, the testimony of PW4 Lordship regarding the recovery of seized ganja from possession of the present applicant, Lordship corroborated with the independent witness.
Page,
Lordship, we
PW4,
have filed our objection, Lordship.
we have filed our objection.
Kindly peruse the objection.
Okay, you are reading verbatim from your objection.
Lordship.
What are you, madam?
Lordship, I'm additional public prosecutor.
Additional PP, okay. Para,
Lordship. Para 4,
para 4,
para 2, Lordship.
para 2, yes.
Lordship, PW 1, 2, and 3 were independent witnesses and they deposed that on 13/2/2022 at about 1:40 PM, the train arrived at the station and the GRT personnel boarded the train and searched the coaches, and during the search, the GRT personnel recovered one trolley bag and a sack containing suspected ganja, and the police personnel apprehended 3 persons. They also stated that the accused persons were from Jharkhand and that the weight of the suspected cannabis was 21 kg, Lordship. And Lordship, apparently in the charge, GRP New Bongaigaon was examined and as PW4. And he deposed that on receiving the secret information, he entered the same in the general diary and informed the matter to the officer in charge of Bongaigaon GRPS. And on being authorized, he along with his staff boarded the train, conducted the search and found 3 persons, one of them being the applicant carrying a blue trolley, and on further search, he found suspected ganja in possession of the applicant. He further stated that he and his staff thereafter took the applicant and 2 others to the platform along with their belongings, and that in the meantime, the OC reached the platform, who seized and measured the article in presence of the witness, and it was found that the suspected ganja in the applicant's bag was of 10 kg. So, my lordship, the
If
testimony,
it was 10 kg, then how much was seized?
21 kg.
From where did you get that another 11 kgs?
Lordship, from out of 21 kgs, lordship, 10 kgs suspected ganja in the applicant's bag.
Applicant's bag.
Lordship.
So that means the other bags were belonging to somebody else.
Three accused are there.
Take it. So those belong to the other person.
Lordship.
So that means only how can you charge him
As
under
per the
20B2?
statement of PW4 Lordship.
No, that is your written objection.
Lordship. But Lordship, the testimony of PW4 Lordship regarding the possession of
See,
seizure
one
of
thing
the.
he is saying, the evidence. He's saying that at the time of search, they were not present, the independent witnesses. They were there only for the purpose of giving their signature in the seizure memo. And he says that in terms of the judgment of the Supreme Court and this court, in the absence of any independent witnesses during the time of search, which is required under section 100 TRPC, read with section 51 Indian PS Act. The search was illegal and it reshaped the crime. So they have to be acquitted. What do you have to say to that?
Lordship, the LCO.
No, madam, it's a question of law. It's not a question of LCR.
Otherwise, Lordship, the
What do you say to that?
Lordship, that the Lordship procedure of NDPS Act is complied with Lordship. Procedure, Lordship.
No. Didn't you read the judgment that he was talking about? This is of 2003 9 SCC 159. Out here, no recovery of opium took place in the presence of the appellant. In the face of all this evidence, the Supreme Court said, in the face of all this evidence, we do not find it safe to conclude that the prosecution has established a case against the appellant beyond a reasonable doubt. So, the recovery, the search and recovery was not seen by the independent witness. That's what he's saying. The independent witness only gave their signature in the seizure memo, showing that they had seized it. But the actual search and recovery from where it was done, that was not witnessed by the witnesses. In that case, he said that the applicants would have to be acquitted of the charge. What have you got to say to that, to the Supreme Court judgment? And it talks about another judgment of this court. Single bench of this court has held that as per requirement of section 100, 4 and 5 with section 51 of the Indian PS Act, the officer making search is under obligation to make an endeavor to call upon independent and respectable persons of the locality where the search is conducted or from any other locality. And the search shall be conducted in their presence.
Lordship, it would be, Lordship, lack of independent witness are not fatal to Lordship prosecution case, Lordship.
That is written
However,
as,
such
by whom? By whom?
by constitution. Constitutional bench of Honorable Supreme Court.
Yeah, please give us that.
Independent, independent.
It's by Honorable Justice Ramanna, Surya Khan and Rishikesh Roy.
Citation,
Lordship,
question.
thank you.
Okay, right. Well, they're looking for.
Lordship, there are judgments.
So give it to us. It's like saying uh, there's a lot of good points in our favor without telling us what it is.
2010 3 STC 746, Ajmer Singh versus State of Haryana.
2010,
3 STC 746,
para,
Lordship, it has been relied on in other judgment, SCP block minor. The court to answer the question arising when to observe that it was held by the Honorable Supreme Court of India in Ajmer Singh versus State of Haryana. Though, though in cases like the case in hand, independent evidence is required, but the accused cannot be acquitted merely because no independent witness produced. In light of the precedent cited, the court held that the trial court had committed no error in law in convicting the accused, and acquittal could not be granted only because no independent witness was joined.
no,
Independent witness was joined.
give us this, give us this. Rakesh,
2010 3 STC 746.
Rakesh, 2010 3SCC 746. How is a big judgment?
I'm just getting up.
Is the book is there? Two books. Okay, right. In the meantime, you look for the judgment. Yes, what
My lord, regarding his, her
judgment?
judgment. This is a judgment given by 2018 SCC, 17 SCC, 6 to 7 page, my lord.
2018,
18, 17 SCC to 6 to 7. Mohan versus State of Punjab.
yes.
Here says my lord, the prosecutor has to prove. That
No, it depends. Is the procedure mandatory or not?
page 15, my lord, para 15, my lord. This is important, my lord.
Para 15.
Para 15. Yeah, my lord, it is a hidden,
What is this? This is the normal law.
that,
Foundational facts have to be proved. That's all.
that the position has to recover from our end. The prosecutor has to prove.
Well, the prima facie they have proved it. How can you say that just because you have taken a opposing stand, that we have to believe you instead of believing them?
No, not that. I'm just giving this.
Lordship, we have found that judgment Honorable Supreme Court,
Yes.
three judges bench, it was delivered on October 26, 2020. Ravin Kumar versus State of Himachal Pradesh.
Ravi Kumar
Ravin Kumar versus RAVEEN.
State of Himachal
Yes.
Pradesh, yes.
Supreme Court has reiterated that in NDPS cases, lack of independent witnesses are not fatal to the prosecution cases. The three judges bench of Honorable Supreme Court comprising of Justice N.V. Ramanna, Surya Khan and Rishikesh Roy observed that in such cases, the courts have to adopt a greater degree of care.
The news
while-
article,
No, Lordship.
news article,
No, it's the press to give
Okay.
here. I found it.
citation.
No, it
Just-
may
just-
not be
just take
reported.
out.
Minor.
Let's take out.
Ravin Kumar versus
Ravi Kumar was
Ravi-
State of Himachal. Pradesh.
Ravin,
Ravin. Yeah,
R-I-V-
RIVIN.
WEN, RAVEEN.
Double E N. Ravin Kumar.
Yes, versus State of Himachal.
RAVEEN.
No, it is such court, no.
If I had my
2020,
Court has to look.
October 26, 2020.
Okay, we'll find out anyway. You see, the question of, the question of independent witnesses in 88 PS case, you cannot take it very strictly. Sometimes seizures are made in the forest, in the border areas, where there are no independent witnesses for miles around. What do you do in those cases? You tell me.
Malad, if there is some case, I
Can-
didn't bring that.
No,
Malad.
no, no.
If you have prior information, he should have added by the time. And here is
No.
their prior information.
And if you take prior, if you take, you see, if you take prior, then they are open to the charge of being professional witnesses also. Anyway, those are different issues, right? Heard Mr. S. Mitra, learned counsel for the applicant. Also heard Miss
And us.
Endas, learned additional PP. This is an application under section 389 CRPC for suspension of the sentence and release of the applicant on bail. The brief facts of the case is that the applicant, along with two co-accused, Bipin Kumar and Veera Mahato, had been arrested for possession of 21 kg of ganja. From the Bongaigaon train station. Usna. The ganja had been recovered from one blue colored trolley bag and two polythene packets. This polythene packets, what was it? And two
One
what
trolley
packet?
bag and a sack containing suspected ganja.
Two what?
One trolley bag and a sack containing suspected ganja.
And one sack, not two. And one sack,
One sec,
and one sack, and one sack.
one number packet wrapped with brown color.
Full stop. Consequent to the recovery of the ganja, comma, special NAR, special bracket NAR, bracket close, case number 23 slash, no, bracket BGN of 2022 was registered. No, sorry, this is not the case. What was the case? Where is the judgment in order?
My lord, judgment order, my lord. Page. Page 62, my lord. From page 62 to 93.
Wait, then you write, consequent to the recovery of, so Bongaigaon GRPS case number 02 of 2022 under section 20B2C. 20B bracket 2 bracket C slash 29 NDNPS Act was registered. After charge sheet was filed, the case was registered as special bracket NAR bracket close case number 23 bracket BGN of 2022 in the court of the special judge Bongaigaon. The applicant along with the two co-accused were thereafter convicted under section 20B2C of the NDNPS Act and sentenced to undergo rigorous imprisonment for 15 years with a fine of rupees 1 lakh, in default, SI for 6 months. The applicant's counsel submits that the sentence imposed upon the applicants should be suspended in view of the fact that there were no independent witnesses who had seen the search and recovery of the ganja from the blue colored trolley bag or the sack or he submits that the Caesar witnesses not having seen the search and recovery of the contraband, comma, the provisions of section 100 bracket 4 bracket 5 read with section 51 of the NDNPS Act. 100 CRPC, huh? 4-5 CRPC. Read with section 51 of the NDNPS Act had been violated. And as such, the same vitiated the trial proceedings. Accordingly, the applicant would have to be acquitted of the charge due to non-compliance with the mandatory provisions required under the CRPC and the NDNPS Act for conducting search and recovery of the contraband. He also submits that section 50 of the NDNPS Act was not complied with, as no magistrate or gazetted officer had been called at the time of search of the applicant and the co-accused. He submits that section 41(2) of the NDNPS Act has been violated, as the sub-inspector who took down the information in writing with regard to the information regarding transportation of contraband drugs was not an empowered officer. First, he also submits that there being a time gap between the recovery of the ganja at 1:30 and the Caesar memo which was made at 4 p.m. The same gives rise to a suspicion that the case against the applicant is a fabricated case. He also submits that the prosecution failed to prove that the applicant was in conscious possession of the recovered drugs. Combined as much as the blue trolley bag did not belong to the applicant. Correct? Or does it belong to you?
Pardon?
Does it belong to you or not?
No, I'm not good. Madam, one thing I would like to, the judgment is quoted, she has quoted, my lord. Here in case of, it is, I'm just reading, my lord, very important in case of chance.
Chance recovery.
The judgment in case of chance, but in my case is the prior information. That witness will not be fatal, independent witness in case of chance recovery. But in my case, it is prior information. It is different. Para 6.
We'll have to see, but the chance recovery, no doubt. But then what about, you see, like I said, they get information.
Yeah.
And then they have got to wait in the jungles for 2 days sometimes, 3 days sometimes. They might take a
Well,
person, but then those persons go there, what do you do? It's not a chance recovery.
Definitely, man. But
So,
in this is the
In
case.
the facts and circumstances of each case.
Yes, factors are different factors are each case. My case is a simple case. Train is coming. Everybody knows that the train is coming. You should have prior information. So
No, but then sometimes the information turns out to be false also.
in other cases,
You see, sometimes they say that he's coming with a, say like this, like in a blue bag, with a blue bag. Or he's coming in a motorcycle. And then, or he's coming in a cycle. With say around 30 kgs of ganja. And there's no question of if he's not carrying any bag, he's coming in a shorts and a t-shirt with a chappal in a cycle. And you don't see anything, no bag. 30 kg is quite big. There's no question of stopping. So you can't take a witness all the time. Then what happens? So we'll have to see. We'll have to see. I do not know whether this will be the right time to release, especially when your co-accused have been.
well, the paperwork will take some time. It will take a long process. 1 2 years. At least he should be released for some time, my lord. Given a time, that's 3 months, 4
He'll
months.
disappear. He'll disappear. He'll go back to.
No, my lord, he will not disappear, my lord. I don't think he will disappear. But at least he seems he has a handicap and needs some treatment. Or that only on medical ground. He will be released for 3 months, 2 months. Then let him be just.
What do you do traveling without luggage when you are a handicapped person?
No, sir. He is suffering from hydrocele, my lord. Hydrocele.
What is that?
It is a disease of urinary tract infection. Urinary
Urinary
bladder.
tract infection.
Urinary bladder.
What were you doing in Bongaigaon? What did you come to do there?
And the Bonga Civil Hospital, what I'm doing in Bongaigaon. He's traveling. No, he's traveling back to Jharkhand, my lord. Not Bangalore, accidentally Bangalore. He's traveling from Agartala to Jharkhand.
Yes, which the principal. Who has given this? Prosecution. Oh, okay. The principle of parity criminal case is that where the case of the accused is similar in all respects as that of the co-accused, then the benefit extended to one accused should be extended to the co-accused. Ah. Okay, right. Whatever I said. Her blue colored trolley bag did not belong to the applicant. He accordingly submits that the that the sentence should be suspended and the applicant should be allowed. on. Miss
And this.
and thus the learned additional PP, on the other hand, submits that that this court you see, already the suspension of sentence has been rejected in a similar case.
It's similar case that this case is different, my lord, and my case is different, his ground is different.
Same sentence.
But my lord, another thing, my lord. second time-
Same sentence, rather.
Same
You
sentence.
are the prime
No, my
accused
lord,
because
but,
you are carrying
In
the,
that case, the
holding the
section
trolley.
29 of Independence Act should be applicable. Here in this case, not that. Not criminal
rather
intention,
he
not
is the
yet.
prime
proved.
accused.
Criminal intention is not in, no conspiracy. That has been not has been adjudicated for criminal conspiracy.
What happened? What happened? Ravin Kumar. Okay, right. On the other hand, submits that the two co-accused / appellants, that is Bipin Kumar and Veera Mahato, had filed IA criminal 573/2023 before this court. Praying for suspension of sentence and bail under section 389 bracket 1 CRPC. So, however, this court, while order dated 26/9/2023, dismissed the application of the co-appellants on the ground that it was not appropriate to suspend the sentence imposed on the co-appellants at this stage, comma, more so due to the embargo of section 37 of the Indian Press Act, 1985. Full stop. Next paragraph. With regard to the issue of whether the absence of independent witnesses during the search and recovery of persons, search and recovery of contraband was fatal to the case of the prosecution. comma. Various judgments have been produced by both sides. Full stop. The judgment of the single bench of this court in the case of so and so reported in 2021, 1 GLT 790, and the judgment of the Supreme Court in the case of Jagdish versus State of MP, 2003, 9 SCC 159. Is to the effect that in the absence of the independent witnesses at the time of search and recovery. It would not be safe to conclude that the prosecution had established the case of recovery of contraband drugs from the accused person. Good stuff. On the other hand, the judgments of the apex of the Supreme Court in the case of Ajmer Singh versus State of Haryana, 2010, 3 SCC 746. Is to the effect that though it is normally expected that there should be independent evidence to support the case of the prosecution, with regard to search and recovery of drugs, comma, the same was not an inviolable rule. INVIOLABLE. Inviolable rule. It further held that in the peculiar circumstances of that case, comma, the Supreme Court was satisfied that it would be a travesty of justice, comma, if the appellant was acquitted merely because no independent witnesses had been produced. It further held that it may not be possible to find independent witnesses at all places, comma, at all times. The obligation to make public witnesses is not absolute. Full stop. If after making efforts which the court considered in the circumstances of the case reasonable, comma, the police officer is not able to get public witnesses to associate with the raid or arrest of the culprit, comma, the arrest and the recovery made would not be necessarily vitiated. The court will have to appreciate the relevant evidence and will have to determine whether the evidence of the police officer was believable after taking due care and caution in evaluating their evidence. First up. In the case of Raveen Kumar, RAVEN Kumar versus the state of Himachal, the Supreme Court, no, wait, before that. What is the case number? Criminal appeal numbers number 218788 of 2011, comma. The Supreme Court has held that the Supreme Court has held as follows. You just take it down from here, huh? From the above being said, comma,
Here, man, the para six. The chance with this, what they come
the
in para six.
the above being said, the present case, the above being said, comma, the facts in Raveen, the facts in the case of Raveen Kumar Supra appears to be one of chance recovery.
Yes.
I think even in this Ajmer thing it is done. So similarly, in the case of Ajmer Singh, the facts seem to indicate that it was also chance recovery. Next paragraph. In with regard to the question as to whether there was violation of section 50 of the NDPS Act. We are of the view that the contraband having been recovered from the blue trolley bag and sack and one sack, comma. The the recover, the same does not come within the ambit of section 50 of the NDPS Act. The applicability of section 50 of the NDPS Act would only come into play when there is a search of a person and a recovery of drugs is made from the body of the said person or the clothes he is wearing. It would not apply to cases where recovery is made from a bag being carried by any person or belonging to any person or alleged to be belonging to any person. Next, full stop, next paragraph. The case of the prosecution being that the blue trolley bag was being held by the present applicant and that the sack also belonged to the co-accused, comma. It cannot be the question of the question that no, the stand taken by the applicant that he was not in conscious possession that does not appear to be and no, the ground for the prosecution to allege that the applicant was not the owner of the blue trolley bag cannot be wished away. Just now. You have to be careful. Otherwise, in your appeal, we'll be deciding your appeal otherwise. Just now. On considering the other issues raised by the learned counsel for the applicant, juxtaposed with the decision of this court in rejecting the similar application made by the co-appellant in IA Criminal 573/2023, comma, we are of the view that the the case of the applicant hearing being similar to the case of the co-accused, the rejection of IA criminal sense of sense would also have to be extended. Would also have to be considered while disposing of the present application. Accordingly, we are of the view that the prayer for suspension of sentence cannot be granted at this stage. So consequently, the application for bail is also rejected. I is accordingly disposed. The observations made and the decision taken in this application is not the will not be considered to be the final decision to be taken, will not be considered to be the final decision or observation made while disposing of the appeal.
Why not, it's a matter, if we give a release only for 3 months or 2 months, then at least the time period for medical treatment, that will be
Yeah.
better, why not? And if you release for 1 month or 2 months, why not?
No, why? Why?
Why? Because of the treatment, why not?
What treatment? You have not said any treatment. He has just come for
He just consider medical 1 or 2 months, why not? That, no, with some bonds or undertaking.
then right in the main appeal, right in the main appeal. As LCR has arrived, has it, no? This is the main appeal. I think in the analogous appeal, the thing might be there. Has the records come in the earlier?
Yes,
case?
yes, yes.
Records have come in the sub.
I'm not aware of it, but Cosmos is showing no SCI is here.
No,
No,
here,
no, because you see, they have filed the appeal also, na, the co-appellant. That is criminal appeal 171. They have filed that. Right, that's right. In the main appeal, you right. This court, in the order dated 25/9/2023, had directed that if paper book had not been prepared in the analogous appeal, comma, that is criminal appeal 171/2023, paper book should be prepared in this case, as both the appeals have arisen from the same judgment and order. So, sir, list this matter after 4 weeks, along with criminal appeal 171/2023. Yeah, but there is one thing, slightly, we'll have to clarify. See, there is one aspect which we do not want to go deep right now, because we'll be basically deciding the appeal. Whether the absence of an independent witness at the time of search and recovery, would it be fatal to the case of the prosecution? Given the fact that prior information had been given to you and it was in a police station, I mean in a railway station, where people are there. Because if we decide that, it is, so that aspect we have to go deeply with, by looking at some other judgments. Be ready with that.
Ma'am, please, with regard to the yesterday's matter, Lordship, will kindly see the section 222 of the CRPC,
222.
222 subsection 2. When offense proof included in offense charge. Lordship got it.
No, that is all right.
Regarding the minor.
Minor.
Now your lordship will kindly see so far 363A is concerned. I proceed. Here the maximum sentence is life. 63A.
Apart from
Acha,
that,
page 36. Page 36 is there.
35 is a continuation.
36, 37, 38.
My paper book contains nothing. 36 is only the above examination was taken in my presence in hearing.
No, no.
I may be wrong.
Just show it. First.
Oh. My cases do not contain 36, 37, nothing. Lordship, let it be provided to me, then my argument. will
No,
be-
how is your paper book? Your
Hello.
pages are, just show me your paper.
Yes.
Thirty-seven is there.
No
38,
questions.
39.
35, only one question was put.
Yes, I don't have this.
Case number to solve, Nila, case number.
Fifty-two. Then 35. Yeah, I don't know. 50. Continue. Page 75, let me see. Page 75 is also, no. Different.
It happens, my lord, under the I made my submission.
So we'll tell them to provide a new paper book for that. No, it is not only. We do not have this. No, you don't have this. Your page 35 and my page 35 is same. 36, 37, it's all different out here. Out here have page 36. Yes, yes. Page 37 is this. 30, 38 Yours is not ready. Okay, right. Heard, Mr.
PJ Bora.
PJ
PJ Bora. Bora.
Vara, learned counsel for the appellant. Also heard Miss B. Boyan, additional people. First one. We have noticed that that some pages of the paper book in the court records does not match the contents of the paper book given to the additional PP. Accordingly, registry is directed furnish a fresh paper book to the additional PP, Ms. B. Boyan, as is part of the court record. As soon as the new paper book is given to the learned PP, the learned PP shall return the old paper book. That is
I have
the
marked it
possession.
here.
No, no, it's okay, the entire thing, Vibha.
While reading, I marked it. I was under the impression in 313 procedural formalities were not followed. So like I was about to make this submission to send
It
it
is
back.
there, it is.
Yes. That's all.